Defendant's last payment was made on August 16th of 2022. So he made payments on this account for over 4 years. It's the use of the card that creates the contract. And
There's no evidence that I used the card.
Sir, Judge, can you please stop him from talking? He's going to have plenty of time to.
This is, I believe, a pretrial conference.
Your Honor, it should be set for plaintiff's motion for summary disposition.
Oh, thanks for that correction. All right, and I know that two of you have had an opportunity to meet.
Yeah, unfortunately, we weren't able to resolve this one, Your Honor. We're going to move forward with the motion.
All right. Yeah, if you can just give me a moment to review the paperwork.
No problem.
All right, so yeah, I've reviewed paperwork and we can proceed with your motion, Mr. Werber.
Great. Thank you, Your Honor. This case is involving an Amazon credit card issued by Synchrony Bank. The credit card account was opened up on March 26, 2018. Defendant's last payment was made on August 16th of 2022. So he made payments on this account for over 4 years. The final billing statement, which is attached to our motion, was mailed to the defendant at his current address. This was the February 2023 statement, and the balance on that statement was $1,782.66, the exact amount the plaintiff filed this lawsuit for. The defendant did send us discovery, which he claims we answered incomplete, but I want to point out to the court that we mailed him 87 pages of documents for his review. This included months and months of monthly billing statements showing charges made on the account. Most of these charges were made to Amazon and payments made by the defendant each month on the account. This is an account-stated lawsuit. When the defendant receives the monthly billing statements, he has 60 days to dispute those statements in writing, and the defendant did not dispute those and hasn't provided to the court in his answer or in his response to this motion that he ever disputed the balance. And by making payments each month, that means he agrees to the balance. He also disputes the chain of title and the assignment here. The plaintiff provided, attached to its motion, we provided the bill of sale, the redacted line item showing this exact account was assigned to the plaintiff, and most importantly, we provided a letter from the original creditor, which was mailed to the defendant at his current address, a letter from the original creditor informing him of the assignment. So plaintiff has met its burden and beyond with all the documents that we provided to the defendant, both in discovery and attached to our motion. We have proved our case. Now it's up to the burden switches to the defendant. And according to MCR 2.116 G4, the adverse party may not rest upon mere allegations or denials or affidavits. He must, by documentary evidence, set forth specific facts showing that there is a genuine issue for trial, which he has not done. He has never stated this wasn't his account, that he didn't make charges, that he didn't make payments. Again, all these monthly statements, you can see the address. They're mailed to the address he currently lives at. He continues to say there's no signed contract. Again, it's the use of the card that creates the contract. And
Judge, no evidence that I used the card.
Sir, Judge, can you please stop him from talking? He's going to have plenty of time to talk.
So, Mr. Gorman, the way this procedure works is only one person can speak at a time. Mr. Werber is making his argument. When you respond and make your argument, I'll prevent Mr. Werber if he would interrupt from speaking. So we don't have two people speaking at the same time. We can't record two people talking at the same time. and it's not a good way to proceed with a hearing in court. So if you can refrain yourself from speaking while Mr. Werber is speaking, that would be greatly appreciated.
Okay, I apologize.
You think you can do that, Mr. Gorman?
Yes, I apologize, Your Honor.
Thank you, sir. Mr. Werber, you continue.
Thank you, and I'll just wrap this up. Defendant, it seems like defendant's defense is lack of standing. Again, plaintiff has provided a complete assignment. The assignment paperwork, the bill of sale, the redacted line item showing this exact account was assigned to the plaintiff, and most importantly, that letter which was attached to our motion that from the original creditor informing the defendant of the assignment. He's asking for a signed agreement. There is no signed agreement in credit card cases. It's the use of the card that creates a contract. The monthly billing statements show that the defendant used the card and made monthly billing statements. He hasn't provided in his answer or his response that he ever disputed those monthly invoices, which is required. He's claiming that that the balance is incorrect. That's not true. Again, the last monthly billing statement mailed to the defendant is the exact balance that the plaintiff prayed for in its complaint. He's stating there's no existence of a contract. Again, it's the use of the credit card that creates a contract. And he's saying that defendant is the correct debtor. I don't know what that means. He is the correct person. And again, we provided 87 pages of documents proving our case. The defendant has provided nothing. And again, pursuant to MCR 2.116G4, the adverse party may not rest upon mere allegations or denials or an affidavit. That's not good enough. He must provide documentary evidence, set forth specific facts showing there is a genuine issue for trial, which he has not done. Plaintiff is entitled to a judgment based on MCR 2.116C9. Defendant has failed to make a proper defense here. And based on MCR 2.116C10, there is no genuine issue of material fact for trial, and plaintiff would be entitled to a judgment here.
All right, well, thank you. Mr. Gorman, now there's your opportunity, sir.
I object to everything that he said. The 87 documents that he claims that they sent are unverified screenshots of that could be, I mean, who says that they're not altered? They were unverified. Their affidavit is not based on personal knowledge. It was based on a review of original creditor records that I still have not seen. Their bill of sale does not state a specific account or name. So therefore, they have not met their burden of proof under MCR 2116.
So, okay. So, Mr. Gorman.
Can I add that a lot of those pages that they sent were blank as well? There was nothing on them. And
Okay.
my sworn denial that I sent in disputes this debt entirely, in its entirety.
Okay, I hear what you're saying, Mr. Gorman. And the last thing that the court wants to see is someone responsible for a debt that's not theirs. But on the other hand, it doesn't make a lot of sense to go through a lengthy trial if the evidence supports.
There's no evidence that supports it. I also filed a motion to compel, which is pending, which requests elements that is.
All right, but you know, I've looked at your paperwork, and you don't deny that you use that credit card.
I do. I deny it now. I deny that I use the credit card.
Well, but in your paperwork and affidavit, I don't see where you deny that you use that credit card or you incurred debt on the credit card. Simply that you don't agree with the paperwork they provided you, or there's not a contract. But I agree with Mr. Werber. There's not a requirement that there be a written contract if the parties had a course of a business, a course of conduct where
Okay, yes,
you
but-
used credit card in the past, and you know the parties.
Where is the proof?
Argument here? If I can just finish, Mr. Gorman, the argument is that listen, you used that credit card for several years without complaint, and that you simply failed to pay the balance due. And I don't see anywhere in your paperwork where you're saying, listen, that's not me, it was someone else's debt, or I never used that credit card, or
Okay, well,
it was a fraudulent use of the card.
any factual determination would require admissible evidence at trial, not argument.
All right. Is there anything else you'd like to say, Mr. Gorman?
No, that's it.
So, all right, as I've indicated, I really don't see where you're denying that you use this credit card
Ain't it?
or that it's
I
your
did the whole thing.
debt. You're just denying that there's not a contract or they haven't provided sufficient proof. However, the proof has been established that it's acceptable to transfer these credit card debts and for one party to purchase that debt from another party. And as Mr. Werber has pointed out, he's provided the documentation of the assignments that allows the plaintiff to pursue this case. And your paperwork's not really denying that you used the credit card. You're just claiming basically they haven't provided sufficient documentation, which I think is, in my opinion, incorrect because they provided the documentation. So your statement of insufficient evidence is without merit and without basis. I am granting Mr. Werber's motion for
The plaintiff holds the
disposition.
burden of proof on this. The plaintiff
Thank
holds
you,
the
Your Honor.
burden
I
of
did
proof that
attach
they
a
have not
order
proven.
to the motion. You
Motion
should have it. If you need me to
still-
submit another order, I can, but I did submit one with the motion. It should be after the brief, but before the exhibits. But again, if you can't find it, I certainly can submit an order.
Yeah, I don't see it, Mr. Werber.
All right,
Okay, so
I will.
who do I file a motion to
I'll
reconsider.
submit an order.
I still have a motion to compel as well. With elements of this case.
All right, yeah, you'll have to submit the order. I don't see one in the file, Mr. Werber.
No problem at all. Thank you, Your Honor.
All right, thank you.